Great. Okay, hi everyone. I am a PhD candidate at the University of Melbourne. I am currently at the Gold Coast, so hence the beach background here. I'm sorry I couldn't be with everyone there in person, but I have loved, engaging online yesterday and this morning. And in my presentation today, it picks up really well of Nina's presentation in considering how the concept of loss and damage is being shaped by different actors, and particularly how Pacific Island states have shaped the concept of loss and damage. But also the way in which this concept of loss and damage has been contested under international law, and what that means for how Pacific Island states can access support for addressing loss and damage. So to begin, I will provide a brief account of how loss and damage has been understood by different states and groups of states in international climate negotiations, paying particular attention to the proposals made by Pacific Island states, both individually and as part of negotiating coalitions such as the Alliance of Small Island States. I will then demonstrate that there is limited consensus on how to understand and address loss and damage, yet these controversies notwithstanding, certain approaches to addressing loss and damage have been prioritized. As Nina mentioned, insurance and disaster risk management mechanisms, and increasingly private finance. Even with the recent establishment of funding arrangements for addressing loss and damage, I will show how effective and accessible support for addressing loss and damage in a manner that accounts for the special circumstances of Pacific Island states and other vulnerable countries remains deferred. I will conclude my presentation by reflecting on the extent to which current approaches to addressing loss and damage under the climate regime support or perhaps even undermine the project of climate reparations. So to begin, what do we mean when we talk about loss and damage in the context of international climate negotiations? Well, the concept first emerged in the negotiation of the UNFCCC in December of 1991. The Pacific Island state of Vanuatu submitted a proposal on behalf of AOSIS, the Alliance of Small Island States, for the establishment of an international insurance mechanism, but specifically to compensate small island states for loss and damage resulting from sea level rise. The insurance mechanism was to be funded by the mandatory contributions of developed countries on the basis of their carbon dioxide emissions in the year prior to their contribution to the pool, as well as their gross national product. So how much they emit and also how much resources they have. The funds, in turn, were to be distributed to those most vulnerable, small island and low-lying coastal developing countries. Now, while this proposal was included in several draft texts of the UNFCCC, it was ultimately omitted from the final adopted text. Still, this initial proposal paved the way for the concept's inclusion and evolution in numerous decisions of the Conference of the Parties to the UNFCCC in the following years. The first decision to include an express reference to the concept of loss and damage was the Bali Action Plan in 2007, which focused on enhancing action on adaptation, considering disaster reduction strategies and means to address loss and damage. Here, loss and damage was introduced as part of the existing adaptation and disaster risk management framework, rather than as a separate and distinct issue. This can be contrasted to several successive proposals made by the Alliance of Small Island States in the following years, which recognize the role of adaptation in enhancing resilience to the adverse impacts of climate change, but really stressed that loss and damage required responsive measures, including compensation, in addition to those anticipatory adaptation and risk management measures. This understanding of loss and damage was, to some extent, reflected in the establishment of the Warsaw International Mechanism for Loss and Damage, or the WIM, which was established in 2013. It was established under the Cancun Adaptation Framework. So in doing so, it maintained an association between adaptation and loss and damage, despite this push from small island states and other developing countries to recognize loss and damage as a distinct issue. And yet, the decision establishing the WIM also recognized that loss and damage raises issues that go beyond the limits of adaptation. And so what did that mean in the lead up to the Paris Agreement? Well, for Pacific Island states, they adopted the Suva Declaration on climate change. The Suva Declaration identified a handful of issues that Pacific Island states called for the agreement in Paris to resolve. Critical among those issues was the recognition of loss and damage as a distinct issue from adaptation, and the need for increased financial and technical support for Pacific Island states in addressing the adverse effects of climate change. The inclusion of a dedicated article on loss and damage in the Paris Agreement went some way to addressing the issues raised in the Suva Declaration. Article 8 of the Paris Agreement recognizes the importance of averting, minimizing, and addressing loss and damage. Without defining loss and damage, the agreement indicates that it includes slow onset events, such as sea level rise, which was raised in the initial proposals by the Pacific Island states, as well as extreme onset events. It also recognizes the role of both economic and non-economic loss and damage. In these areas, the Paris Agreement encourages parties to enhance understanding, action, and support, but on a cooperative and facilitative basis. The inclusion of an article on loss and damage entailed a compromise on the part of Pacific Island states and other vulnerable countries. The COP decision stated that Article 8 does not involve or provide a basis for any liability or compensation. This reflected developed countries' key concern in respect of loss and damage, seeking to exclude compensation for damage caused by high greenhouse gas emissions. The legal effect of this statement on the rights of Pacific Island states and other vulnerable states is limited, and this has been discussed in the existing literature on the topic. However, I think it indicates the significant opposition that vulnerable states, like those in the Pacific, have faced in accessing support for harm that goes beyond the limits of adaptation. So, more recently, through decisions made at COP27 in Sharm el-Sheikh and COP28 in Dubai, parties have arguably both clarified and extended the concept of loss and damage compared to its conceptualization in the Paris Agreement. At COP27, parties agreed to establish funding arrangements, including a dedicated fund, to assist developing countries that are particularly vulnerable to the adverse effects of climate change in addressing loss and damage. The Loss and Damage Fund was then operationalized at COP28. In theory, as Nina discussed, the Loss and Damage Fund fills gaps in the current climate finance landscape by ensuring developing countries can access financial assistance for responding to the harmful effects of climate change after they occur. Importantly, it's the first climate finance mechanism to provide support for addressing non-economic loss and damage, such as harm to Indigenous and traditional knowledges, important cultural heritage sites, things that are not easily quantified. The decision adopting and operationalizing the Loss and Damage Fund urges developed countries to continue to provide support for loss and damage and encourages other parties to do the same, but on a voluntary basis. In the context of these voluntary contributions, we see that initial pledges to the Loss and Damage Fund remain largely inadequate, less than 0.2% of the estimated annual requirement. So the Loss and Damage Fund does recognise the greater needs of those most vulnerable and less resource states by requiring a minimum funding allocation for small island states and least developed countries. However, where this minimum allocation will be set is yet to be determined. Neither is a minimum allocation floor, a guarantee for fair or efficient allocation across countries, or equitable access for those most vulnerable. Discussions on access to climate finance go beyond how much money is theoretically available or even who ultimately receives it. It also matters in what form the funds are available, the process required to attain them, the time it takes to deliver the funds, and the conditions attached to those funds. Access to climate-related international finance has been and remains a significant challenge for small island developing states, including those in the Pacific. access to funding in the Pacific is quite limited to date. There are structural impediments to why international funds are not financing adaptation and mitigation in the Pacific at the rate needed. Most funds do not account for the special circumstances of small island developing states in a meaningful way, including their extreme exposure to disasters, remoteness, lack of capacity, and small population sizes, but also their interconnectedness, their traditional knowledges, and how this should be incorporated and prioritized when considering what mitigation and adaptation measures are needed. And there is a direct correlation between this lack of access to climate finance for resilience and adaptation measures and the mounting costs of loss and damage in the Pacific region. So in the lead up to COP29, one of the key priorities for the Pacific was ensuring that COP29 delivered on climate finance. This included reinforcing calls for minimum allocations of finance for small island states and least developed countries, as well as guarantees for grant-based finance directed towards climate-related loss and damage. Pacific Island countries and other climate-vulnerable countries called for developed countries to provide US 1.3 trillion a year in climate finance, which is still only a fraction of their actual needs. However, the commitment was far below this and entailed no binding commitment to provide minimum allocations to small island states or least developed countries. As the procedures for how the new fund for responding to loss and damage will raise and distribute its resources are still to be worked out, it is an opportune time to reflect on how international funding arrangements may contribute to the project of climate reparations. As Tendaya underscored yesterday in her presentation, reparations require addressing historic climate injustice, as well as eradicating contemporary systemic racism that is a legacy of historic injustice in the context of the global ecological crisis. In this way, climate reparations must be both backward and forward-looking, recognizing historical injustices and seeking to provide a systemic approach to redistributing resources and improving the lives of those that are disproportionately affected by climate change. The funding arrangements for responding to loss and damage go some way to supporting this project. They do provide a mechanism to redistribute resources, ideally from developed countries and potentially high-emitting private entities, to those developing countries, and especially those considered most vulnerable to the effects of climate change. As Nina highlighted in her presentation, there are opportunities under the Loss and Damage Fund to enhance regional cooperation on loss and damage, with the aim to ensure that those funds reach communities and peoples on the ground. However, as Alefi Otaiwo has argued, financial compensation is a necessary but insufficient mechanism to provide full reparations for climate harm. In addition to compensation, Taiwo has emphasized the need to shift power and control over democratic processes to disproportionately impacted communities. And yet, what we have seen in international negotiations on loss and damage is Pacific Island states and other climate vulnerable countries pushing forward the concept of loss and damage, but the actions that are being implemented to address loss and damage are not addressing their demands. For example, it remains to be seen about the minimum allocation floor for funding arrangements. With COP30 being held in Brazil, and with the potential for Australia and the Pacific to host COP31, there are key opportunities for this project of shifting power and control to those most affected, including Pacific Island states, but also First Nations people, to ensure their demands for addressing loss and damage and climate reparations are heard. I'm really looking forward to hearing the other presentations today on this topic of shifting the power, and thank you for your time.